Hello and welcome to the Workwise for Screen podcast, created to help our screen industries better look after all the people their businesses depend on.
And stay on safe legal ground. It's part of a growing collection of practical resources and guidance that you can dip into without it taking you forever or costing you anything. It's supported by the BFI, awarding national lottery funding.
We'll be talking with people across production, distribution and exhibition, animation, VFX and gaming about the challenges to well-being we face when deadlines and budgets are tight, and how, most importantly, to improve things. We are your hosts, Tasita Small from the Small HR Company, the HR for Entertainment one,
and Keith Arrowsmith, the legal one, a creative industries solicitor and program director for Workwise for Screen. Tasita can't be with us today, but in this episode, I'm going to be talking about why businesses use non-disclosure agreements, or NDAs. What type of information do they protect? When should they be signed, and by who? What protections need to be put in place when we're drawing up NDAs? Peter Adediran is a founder and intellectual property lawyer at Pail Solicitors. They specialise in intellectual property, digital media and international commercial law. They've worked in screen media across a wide range of genres, from documentaries to illustration. Peter covers contracts, licensing, litigation strategy for intellectual property and defamation defences. He also wrote a book called A Practical Guide to Business, Law and the Internet. Let's talk to Peter now. As ever, we don't know every listener's specific circumstances, so we can only provide general guidance to introduce the subject. You may need to talk through your situation with a specialist before making any final decisions. At the launch event for the Workwise for Screen podcast, I highlighted a production company's contract, which had one of the longest, most complicated confidentiality clauses I'd seen in a very long time. So it feels quite complicated before we even start. So take me through how it works in practice. What do you do when a business comes to you and say, we need an NDA?
I think we have to go back to basics. You have to look at the material, the scope of the material. So it needs to be tailored. So that's the first thing. What are we trying to protect? And there are two categories that we're trying to protect. The first category would be creative. I'm in the business of ideas. I'm an IP lawyer. So primarily my clients are creatives, innovators. So creative commercial material. And by that, I mean scripts, budgets, schedules, pre-production, casting. That would be what I'd consider to be commercial. So it would impact the financial aspects of the film or the television series. And then the other aspect, which I think is separate, would be personal, private matters that would impact reputation, personal reputation. That would be things like health information on where you live. So if, for example, a call sheet might have contact information on there. It might even have health, this actor needs insulin, for example. All that would need to be legitimately protected as part of a confidentiality agreement. One of the ways where that scope needs to be carved out is where the information is not necessarily relevant. It's simply not a legitimate material to be protected. For example, where it blocks PIDA, the Public Interest Disclosure Act, 1998, protected disclosures, such as criminal activity, regulatory breaches, wrongful activity. If I expand a bit more, so for example, in a movie context, you have several people involved. You have runners, cinematographers, casting directors, crowd directors. You have a whole number of people involved in a movie, in creating a movie. And it doesn't make sense to have a blanket NDA for everybody because not everybody has access to the same level of information. You wouldn't expect a runner to have the same information as the casting director, who would see the script, the final cut, and have them both signing the same NDA. I would say would fall outside the scope of what an NDA is designed to do. So that's the sort of thing I would consider tailoring and carve-outs and clear, plain English that is proportionate. That's how I would approach it.
It sounds to me we've also got a way of making sure that NDAs help us not just as a shield to kind of protect ourselves, but also might end up being a bit of a sword. We can attack people in order to make sure that we are able to deal with these kind of situations that are quite complicated.
Well, first of all, NDAs should never be used as a sword to stifle whistleblowing or to stifle wrongful acts or to punish those who in good faith are trying to bring wrongdoing to light. It should always be a shield to protect creativity, commercial activity, and privacy. Okay? There has been government policy led decisions that have led to ensure that when you are drafting NDAs, they don't do anything to support criminal activity or regulatory breaches. So that's one of the resources that a lawyer can turn to when trying to draft NDAs. Don't draft or enforce NDAs that block reporting of crime, misconduct, or regulatory breaches. Don't use NDAs to intimidate, for example, have financial clawbacks to dissuade disclosure. Make sure you're not doing anything to exclude the protected disclosures, and make sure that you use and you don't stop anyone from seeking legal advice or medical health advice. You can also there are also guidances from the guidance from ACAS as well. ACAS have got guidance on settlement agreements, and you should also have internal reporting procedures as well, so that there's this process in place when dealing with NDAs.
That also reminds me that we're dealing with a sector that has an international base. How do you think around NDAs when you might be dealing with people who are not based in the UK?
I think the first thing that springs to mind is NDAs must be clear, and you must be able to understand them. So I think the first thing that springs to mind is the fact that they may not speak English, for example. So they may not understand the NDA. So what I would encourage is that you get the clauses which should be tailored and specific in scope. There is a balancing act, and the courts do take careful consideration of the wording of the NDAs. So you need a properly translated NDA from a qualified translator, from the people receiving that. You also need to consider what the local laws are in the NDA of the receiving party. So, would it be fair to have English law and English courts, for example, for a receiving party that is based in Romania, for example? The point of a contract is that because that's an NDA is a contract at the end of the day, and the point of a contract is that both parties understand what they're signing, and both parties are it's fair. My view is that commercial matters are better when they're fair. You have a much better long-term relationship with people if you are, honest and fair, and you have integrity. So yes, you've got to consider fairness and something that both parties can live with, particularly if it's cross-border.
Landing on a concept of fairness as an underpinning of the NDA is a lovely spot for us, because Workwise for Screen is all about those good working practices and trying to find ways of rebalancing some parts of the sector where people have felt that pressure of signing up to documents that they might not have understood, or they might not have had the chance to get some independent advice before they signed on the dotted line. So building those into the kind of process at the beginning feels really important. If there is a concern, it sounds as though there can be ways of introducing arbitration or mediation, or ways of trying to preserve that relationship rather than running off to go and talk to a judge.
Again, back to basics. My view is that law should be proactive, not reactive. If you had prepared the contract fairly in the first place and observed the interests of both parties, no one in the contract's going to get everything that they want. You have to reach a consensus that serves both parties, and where both parties can may not have a total win, but they can have some sort of they can understand, they can have a benefit. They can have the benefit, and they understand the responsibilities in that contract that contract imposes on them. So that's always my aim. So if the contract is a really good one in the first place, then you won't end up in court, and you won't end up in mediation or arbitration. It would be something that parties can live with. So I think my answer would be proactive. Make sure that you are tailoring the contracts. Make sure they're clear and proportionate. Make sure that you're carving out matters I've already spoken about. So I think, yes, proactive. Well, if things do go wrong, which they may go wrong, yes, it will be mediation. I would say that should be the start. First of all, get together in a room. First of all, you don't even need mediators. I think a lot of people don't appreciate how far a phone call can go, and how far getting someone in, because oftentimes when people disagree, it's not so much more about the content of what they disagree with. It's about the misunderstanding. And then, it's all about actually understanding what the actor thought was part nudity, and what what everybody understood what part nudity. So it goes back to, again, explaining what it's actually about getting everyone in a room or online and discussing things, and saying, okay, look, this is actually what what is required, and and these are the benefits, and these are the responsibilities, and this is actually what is required. And I think that's the first place. Start with a phone call. Now, if that doesn't work, then get a mediator involved. And if that doesn't work, either arbitration or go to court. The law, the technical law, is that if you breach a contract, then the receiving party can sue you for damages for breach of contract and get an injunction to prevent disclosure. And then if you lose, you end up paying the costs. But none of that needs to happen if you have good lawyers who are the foot soldiers of keeping these things, keeping things out of court. In fact, the primary duty of the commercial lawyer is trying to keep both parties on the same track, and trying to help in the process of promoting creativity, commercial activity, and preserving privacy, because most people just want to get on with making a film, or get on with making campaign. They don't really want to fall out. In my view, taking a proactive approach and using NDAs as a shield, not a sword, is the proper way.
Yeah, I think the lesson here is to have that pragmatic approach at the beginning of the process to make sure you're not using NDAs inappropriately, but also have that pragmatic approach as you're then dealing with the situations to make sure that you're not heading off to court on a point of principle, but rather that you're finding ways of making the best use of that relationship to find a way forward that's going to work, rather than spending huge amounts of time and money and energy on a case that's just going to put more publicity in relation to what could be a breach than a solution. So, Peter, how do we help managers take care to use the right information at the right time when they're thinking about what NDAs should do and what they shouldn't do?
The laws regarding NDAs are continually changing, and staff need to, especially senior managers and executives, need to continually be involved in the education and training for NDAs, and to have internal reporting procedures to ensure that they know what's going on, so that, for example, the actor that now no longer, that thought that they were going to have partial nudity, that ended up with full nudity, the directors and executives know exactly what's going on, and we're not ending up in a situation where that conflict could have been prevented if somebody was able to be involved at a higher level.
Peter, it's been fantastic to hear about kind of how it works in practice with you. So thanks ever so much for helping with that. We'll signpost some of those materials on our Workwise for Screen platform online so that people can find those in that extra guidance, and places like ACAS to kind of help them understand where to go next. Thanks for your time today. Thanks for helping explain that. And we'll hopefully find a place for NDAs in our businesses that's going to be really practical and pragmatic for the future. So thanks, Peter. When we start thinking about NDAs, we need to realise that they can appear to be really heavy-handed. The core function of a confidentiality arrangement ought to be to safeguard the really valuable information that we might be handling, and whether that's in order for an actor to share their personal information so we can make sure they get paid, or it's around someone who needs to tell us about their health conditions so that we can build them into the ways that we're going to work together. And if we safeguard it properly, then we've got this chance of developing a relationship that's built on trust, because we all understand the value of the information and why it's important that we keep it secret. Even little details like the name of our next show, which would really do us damage if they end up being disclosed either on purpose or accidentally to our competitors or to the public before the timing was right. But we can take them too far. And there's been some situations in the past where some people have tried to use NDAs as a bit of a sword, as an attack on people rather than as a shield, as something that's going to protect us and our business information. We can't use it as a blunt tool. We need to make sure it's bespoke enough for the situations that we find ourselves in. So protection on one side, but that public view on what's good for society in order to protect the whistleblowers is going to be really, really important. If you'd like to know a little bit more about confidentiality and NDA agreements, we've got some resources on the Workwise for Screen website. There's a little e-learning module that takes you through some training about what confidentiality is and how that works in practice. And we've got some more information about how data protection works in the screen industries, and especially your responsibilities about handling personal information and sensitive information. And we also talk about the changes that have happened recently in the rules and regulations around whistleblowing and protecting victims from this kind of idea that NDAs can be used as a way of intimidating people. So go to the platform and sign up with your profile, and then we'll be able to keep you up to date with these rules and regulations as they change in the future. Thanks for listening to the Workwise for Screen podcast, supported by the BFI awarding National Lottery funding.
Our online platform provides lots of easy to understand information and invites to our events. Visit our website at workwiseforscreen.org.uk and register for the latest updates.
Please follow us on social media and join in this crucial conversation.
And contact us with suggestions for future episodes, or if you can, support the programme in any other way. This podcast is produced by 1860. Music is by Benjamin Squires.